Join us every Wednesday for InFocus, a weekly talk show produced by the St. Kitts Nevis Information Service, where we provide exclusives with key persons within the government and discuss pertinent, relevant, and interesting matters that affect us all. Tune in every Wednesday, live on ZIZ Radio and streamed live on Facebook at SKNIS Media and ZIZ Online. InFocus, your government, your business.
I'm Ian Richards. Welcome to InFocus, a weekly program where we zoom in on what's happening within and throughout the government, your government. The government of St. Kitts and Nevis, through its Ministry of Justice and Legal Affairs, has signaled its intent to pursue criminal justice reforms to improve access to justice and strengthen the rule of law. This is critically important as the population continues to become more diverse, with persons from other countries integrating into our society. What do these reforms look like? Joining us today is Attorney General and Minister of Justice and Legal Affairs, the Honorable Garth Wilkin, and the new Director of Public Prosecution, Adlai. Stay with us as we delve into your government, your business. Welcome back to InFocus, and allow me to introduce at this time the Honorable Attorney General, Garth Wilkin, and also Mr. Smith. Mr. Wilkin, of course, you've been here before, so it's good to have you back.
Good to be back here.
And Mr. Smith, it's your first time. Welcome.
Yes, thank you. And let me just say it's an honor to be here on your radio program.
And television program, indeed. Right. So we start with you, AG. As we mentioned at the top, and as persons who are looking at this program would have seen the infographic that indicated that Mr. Smith is the new Director of Public Prosecution here in St. Kitts and Nevis. Can you walk us through the process of what is involved in selecting a DPP for St. Kitts and Nevis?
Okay, well, the former DPP, the previous one, his contract ended in September last year. So when we appointed an acting DPP in the interim, and we proceeded to develop the terms of reference that we wanted to put out for the advertisements. So the team within the ministry met, and we said, these are the education requirements, these are the experience requirements, these are the personal requirements that we want to see. And we went about issuing a request for persons to submit their resumes at about, I think it was in December or January this year. And we received 7 applications. And what we did, we then conducted interviews. So an interview panel, the head of the civil service, the permanent secretary in the ministry, the solicitor general, and myself. And we sat with the individuals and we just had conversations. And what was important for me is what the DPP would bring to the table in terms of the advancement of the office of the Director of Public Prosecutions. So that was a key element in our discussion. And at the end of the day, we felt that Mr. Smith was the best candidate out of the persons that interviewed, and he was offered the opportunity, and he gratefully took the opportunity, and we're excited to see what he will be able to bring to the DPPO.
And so what would you say, going back in the interview process, tilted the scales towards Mr. Smith's selection?
He's blushing already. The vision he had, the vision of transformation of the office. I think that was probably, for me, I can only speak for myself, was one of the key elements that separated him from the other interviewees. All quality interviewees, all persons who qualify to be appointed directors of public prosecution. One was actually an existing director of public prosecution in another jurisdiction, and most of the others were senior prosecutors, persons who were just on the cusp of becoming directors of public prosecution. I believe that they will in other jurisdictions. But for me, that was the key, because what we want to do is we want to modernize the office. We want to create an office that is fully functional, that is properly staffed, has the proper number of counsel, so that we can effectively, that office can effectively administer justice.
Mr. Smith, let me bring you into the conversation now in terms of you come from Antigua and Barbuda.
That's correct.
St. Kitts and Nevis. What prompted you to apply for the job here?
Well, I was actually encouraged by one of my compatriots here in St. Kitts and Nevis, Miss Latoya Lake. I just called her randomly one afternoon and I said, Latoya, I'm thinking of applying. What do you think? And she's like, oh, Adlai, we need you. And I'm going like, and Latoya and I are good friends. We've been friends from Antigua. We've worked together, prosecutor-wise or in a prosecutorial context. And I know what she brings to the table in terms of her experience.
And just to mention, she is the head of the forensic unit here in St. Kitts and Nevis.
That's correct. That's correct. So I said, I look forward to the opportunity of working with her. I wanted to get an opportunity to see my vision for our prosecution department actually come to light, right? I think that, and I think it's not just here in St. Kitts and Nevis or in Antigua and Barbuda, but there's widespread dissatisfaction with the justice system, I find. And I think one of the reasons for that, or one of the key reasons for that, is that the stakeholders in the system are not sensitive to the needs and the interests of the people that it serves.
Stakeholders in the system such as?
Well, the politicians who hold the ministryship, or who head the ministries which have responsibility for the courts, number one. Those persons who are actually in the system, like for example, the prosecutors. I can't say the judges, because judges have a very limited role insofar as what they can do and what they can say. The police, and so on and so forth. We must realize at the end of the day, there's a reason why we're called public servants. We serve the public. Once we cease to serve the interests of the public, what in essence we have become? Public masters, if you follow what I'm saying. So, over time, based on my experience with the system and hearing what persons have said about the existing system, and actually having gone on the Rodeo program and being grilled by the public with questions about the system, I realized, the problem is there is a lack of communication between the two. And there is a need to fill that gap. And I'm thinking with what I'm planning or what I'm proposing, it's to help maintain or revitalize confidence in the justice system so that persons can feel confident in it. If persons don't feel confident in the justice system, you know what they're going to do? They're going to take the law into their own hands because they have no confidence in it. So that is the whole idea behind my plan. And I thought, St. Kitts, I had applied for Antigua and Barbuda, but I'm still waiting for them. But I said, you know what? I'm going to use the opportunity, and it will be a chance to do something good.
And so talk to us a bit about your experience in Antigua and Barbuda now. How did that prepare you for the role of becoming DPP?
I think the role which prepared me most for being DPP is the role I had in Antigua before I came here. I've been a prosecutor. I've been a defense lawyer from 2001 to 2004. And then from 2004 to 2019, I was a prosecutor. In 2019 to 2020, what year are we in? 2023? Yes, I was the director of law reform in Antigua and Barbuda. So as director of law reform, I think that role shaped me the best to be for a prosecutor. The thing about being a prosecutor is that you tend only to see the environment that you're in. You don't really look out. As the director of public prosecutions, being outside of the service, I was able to see the problems from an outsider's perspective. And I said to myself, I can see why people have a lot of problems or a lot of diffidence or lack of confidence in the justice system. So over the course of a period of time, I came up with certain strategies to, alleviate that particular problem.
And so you've been here since September. How have you found
Well, I've been actually here since October 6th.
Okay. How have you found the transition?
The transition, well, there's always a little teething issue here and there, but that's been minor here. By and large, I have been, as far as who I've interacted with, petitions and divisions. Petitions and divisions are some of the most friendly persons, the ones that I've interacted with, right? I can only speak for who I've interacted with, but I have not met an unfriendly petition or division, because I've been to Nevis as well too, since I've been here. They've been warm, very receptive towards me. I have no complaint. I might even say, might get in trouble, y'all a bit more friendly than Antiguans, but I have to say that sort of voce.
All right, Adrian, let me turn to you now in terms of course, as we established at the top, the government intends to institute criminal justice reform. Yes. What does that entail?
Okay. What we want, let me start from the macro level. What we want is swift justice. So if you are charged with an offense, you are brought to justice, whether acquitted or convicted, within 2 years.
How long does it take now, average?
The average appears right now, well, it varies. There are a lot of outliers, but I would say on average, from what I have observed, you're looking at maybe 4. There's some matters that are resolved quickly. There's some matters that take a long time. But I would say on average 3 to 4. We're one of the better jurisdictions. There's some jurisdictions in the Caribbean where the average is 10 years. So a person charged with murder is on remand for 10 years before their trial comes up. When you're charging matters in the magistrate's court here, typically your matter comes up within 6 to 18 months. When you get to the High Court now, you have to go through a process in the magistrate's court first, and then your matter is sent to the High Court, an indictment is filed, and then you have to wait for your matter to actually come up on the docket in the High Court. So there's a little longer time between your matter that you did, your first matter. What was the charging date?
2019.
So the matter that the first matter that the DPP did took 4 years from charge to actual trial. So what we want to do is cut that down. The Caribbean has made a commitment at the CCJ conference that I went to. All the Caribbean justice reform ministers and all of the stakeholders want a commitment to 2 years to be from charge to trial, or the resolution of trial. Right? So that's the goal. You accomplish that by cutting off some of the fat in the process. We inherited a British style of prosecution of matters from start to finish. There were a lot of players in the game before you can actually get to the actual game, resolution of the game. So what we're trying to do is to tighten up that process, introduce measures such as possibly reduction in the number of jurors, so that the process for sequestering the jury and what's the language? It's not sequestering.
You're talking about the
panel, impaneling the jury.
Right. At the array.
At the array gets swifter. Potentially introducing, like Antigua has done successfully, introducing judge-only trials for certain offences. So that the matter can be dealt with without the jury array. When you involve a jury, it just adds a lot of extra time to the matter. And expense. Mm-hmm. Expense to the matter. So there's some matters we believe that there's enough experience and enough statistics for us to show that justice is served even if a judge alone. Most of the criminal matters, a lot of people don't realize that, most of the criminal matters in our jurisdiction are dealt with by judge alone, by magistrates. So, and people, they have to give their reasons if they appeal, and they can appeal and they could deal with it. So we believe that we can take that to the High Court. So we're going to have discussions about that. We're going to fix some of our laws. What we're going to do as well, one of the issues with the justice process is that there's not clear, definitive actual criminal laws. So we have these colonized laws A lot of them in the common law, some by statute. But then as societies develop, you have more detailed laws that relate to a particular offense. So for example, the DPP and I, when we were discussing, when I had our first powwow to discuss criminal justice reform, he was talking about, for instance, the Larceny Act. Our Larceny Act is a 19th century act. So it does not speak to certain types of modern theft that can occur by digital means and otherwise. So when you tidy up those things, then you have an easier task as a prosecutor, and a defendant also has an easier task in knowing what you're actually charged with. So those are some of the things that we're going to clean up. Introduce things like plea negotiations. That is big in the US. That is when you take a plea. So you're charged with an offense, and the DPP comes to you and says, listen, this is the evidence we have. If you go to trial and you utilize all of the time going up to trial, all the resources that the DPP has to procedurally get the matter to trial, and we go before a judge, you're likely to get the maximum sentence. However, because of the type of offense it is, we're willing to say, okay, you take 5 years instead of the potential 15.
With the possibility of a lesser charge?
No, but yes, you can do that as well. Mm-hmm. So, for example, there's murder and manslaughter. There is GBH and assault, battery.
Yes.
So you can then negotiate. That has proven quite successful in Jamaica. So what we've been looking at is the regional solutions to our problems. And it gives an opportunity for the DPP to offer. It happens. The DPP, who is the decision maker in the process, the sole decision maker constitutionally in the process, can say, well, this offense, this is really, justice is served, this person serves 5 years. He doesn't make that decision on his own. He also then talks to the victim, because the victim is an integral part in the process. Ultimately, it's the DPP's decision. But you can go to the victim and say, listen, we think we have sufficient evidence against this person. We believe that the justice's situation warrants a 5-year. However, if this matter goes to trial, the range that the judge might give is 5 to 15 years. However, you can get swift resolution in this matter by way of a plea negotiation and offer the person 5 years. You can also offer a co-accused a lesser sentence to then give evidence against the other co-accused. For example, the driver in a drive-by. You can say, listen, you're a co-conspirator. Are you willing to give evidence that will help you to prosecute the actual perpetrator of the shooting? And that will help to speed up the process, because then if you take that co-conspirator out of the process, it frees up the time to then go after the other conspirator. So we're looking at all of those different ways to kind of streamline the criminal justice system. And my goal is by July next year, we have comprehensive reform. We put it into place and we see how it works.
Okay, that's very wide-ranging. So, Mr. Smith, talk to us about your role. The AG would have touched on it a bit, but talk to us a bit about the role of the DPP in these reforms.
Oh, we really needed more than our physician. I'm not going to tell you, because I would only get an opportunity to just skim over them.
Yes.
But it's very important. Let me pick up from where the AG left off. I think the biggest problem that I found, I've interviewed a lot of people concerning the problems with the justice system, because I've been trying to assess what the problems are on the ground. The biggest problem with the justice system is delay. Delay is not an issue that you can just solve in maybe a year or two. It involves you taking very concrete measures that you hope will reap benefits in the long run. The advantage that I have coming out of law reform is that I did an entire paper which deals significantly with how we can tackle the issue of delay. And it starts with risk management by the prosecution, risk management by the courts, plea negotiations, a guilty plea scheme, the importance of public defenders in assisting unrepresented individuals, to name a few. One of the things I want to deal with is, for example, the use of pre-recorded videotape evidence and cross-examination, right? Especially when we have vulnerable witnesses. See,
Explain what vulnerable witnesses is.
Oh, well, vulnerable, it's wide. Vulnerable, at the end of the day, is what you will define it. But like, for example, children are naturally vulnerable witnesses. Persons who are victims of human trafficking are naturally vulnerable witnesses. To give an example, persons who are victims of violent crime are vulnerable witnesses. Persons who have seen violent crime are vulnerable witnesses, potentially, because they may be threatened by individuals who actually perpetrated the crimes. So that's just to give you an example. It's wider than that, but it's how you define it. I'm confronted with a number of matters where important witnesses have left the jurisdiction. Now, let's face it, you can't tell somebody that you can't leave the country until a trial comes up. That you're just asking somebody to put their life on hold for like 4-5 years. And this is why I say, think about the interests of the persons in the system. So I said to myself, why not have a situation whereby as early as possible, as close as possible to the time of the event, you have the evidence pre-recorded video.
Because it's even fresher in their minds as well.
Precisely.
Exactly.
And the addition is that sometimes you get some of the emotion that you can't make up.
That's right.
Yes.
Sometimes people make up crying and so on 4 or 5 years after. You know, jurors have like a raised eyelid with respect to what's going on there. So you have that, and you say that on file. And of course, I've tweaked legislation to deal with this issue because I want to see it happen in St. Kitts. I mean, it was hailed as revolutionary in Antigua, but I think this particular AG has a lot of drive, really wants to see the system going, and I really have to commend him for that. So I think once we put that particular system in place, I think we can do away with the problem of witnesses leaving the country and being unavailable, can't track them. Because once they leave, it's hard to track them down sometimes, you know. And how the Evidence Act is phrased, it's a lot of loopholes that you have to overcome before trying to read that person's evidence as on paper in there. And from experience, I know that reading something on paper to a jury is not the best type of evidence you want to go before a jury for them to make up their minds on a particular issue. So that is one of the issues that I'm gung-ho on. The other issue too, when you're talking about delay, deal with delay too from the kinds of matters which are clogging up your system. You have a lot of simple matters like maybe a pushing or so on, a little fight gone out of the way, it becomes a summary offense. When I say summary, it's tried in the magistrate's court. I think the magistrate's court should be used to deal with serious matters. Take up the time doing, you know, really serious stuff, not the small matters, which are crimes nonetheless in their own right, but think so. What I've suggested there, let's have a caution system. A caution system exists in the UK. One that basically is that once the person accepts responsibility for the commission of the offense, now the legislature will make it an offense to make a false allegation of guilt, because we're not here to have you farm fool, so to speak, in quotations, with the justice system. We want to be serious. So you will have a situation where the person accepts responsibility and you're given a caution document. In other words, behave yourself for the next 3 years. You will not be prosecuted on the matter. And there are conditions attached to the caution. Stay away from, but this can be tailor-made to the individual. It essentially is like what you call a suspended sentence, right, but it's upfront.
Early stage.
Right. And I've seen how suspended sentences keep persons out of the court in Antigua. And I say, why not experiment with that concept with the caution system here in St. Kitts and Nevis, and use that for children, first offenders, even to get rid of some of the matters which are before the High Court right now. But AG mentioned earlier the whole important thing about consultation with the witnesses, right? And if I can just stick in like right here, well, I would have told you in advance that the number of units I want to propose, but I have to be incremental in how I'm doing it, because I come in a situation where my staff is overworked, right? And I have to be sensitive to their issues as well. I don't like to be imperialist, right? I call myself a team leader, and I ask them to call me a team leader. Don't call me boss. I have a different kind of connotation, right? So one of the units is the client care unit.
Right. I want to get into the units.
Okay, let me not jump your gun.
Yes, I'll get into that. But while you were in Antigua, of course, you were the senior crown counselor. And just briefly, I want to just read something that I found here. It's mentioned that you held the post as senior crown counsel in the Ministry of Legal Affairs with responsibility for law reform and special projects.
That's right.
You had referred to that earlier. You prepared a report outlining reforms to the police, larceny, and prison acts.
Yes.
In that report. It was done at the request of Professor Velma Newton, who is the Regional Project Director at the Improved Access to Justice in the Caribbean Initiative. Now, she hailed the report as excellent. Have you identified any of the acts, based on what you're saying, that you would like to do? Any of the low-hanging fruits here in our acts that you would like to tackle right away?
I tell you now.
And very briefly, because we can say
always not enough. Always not enough. The AG already mentioned it, the larceny act, right? I don't want to mention too much of that because there are potential ramifications if the issue has affected here already, and I don't want to open the floodgates. But it needs to be reformed post-haste.
Modernized.
But you need to do it fast, right? In other words.
Okay, and AG, actually, that's a question that I had for you, and you would have touched on it, so perhaps we'll skip it. Skip that question. It was in relation to the type of crime patterns and technology, the things that we are observing, the trends, and the main areas of reforms and adaptation within the criminal justice system to address these contemporary changes. Yeah. These are some of the things that you're talking about in terms of the cell phone.
Just like a constitution lives and breathes and adjusts to the society, so should criminal laws, because technologies advance, people advance in how they commit crimes. So the laws should move with the times. We have a lot of 19th century laws on our books, and it's time, with the help of the DPP. So we're going to collaborate between the Attorney General's office, the DPP's office, to try to modernize our laws. So we have good laws, strong laws, and a strong system to be able to prosecute offenders under those laws.
If I could jump in a second, just to touch on that. One I've identified is your DNA legislation. Your DNA legislation doesn't allow for a prosecutor to apply for a court order compelling the person to give the DNA. So the result is that if the person says no, then all you have is an inference to be drawn of guilt from the jury if they so decide, if there was not a good reason for not giving it. The advantage of when you have the court order to compel the taking of the DNA is that you now have the DNA on file, so that if that person comes out of prison and commits further offenses, you have a DNA profile with which to compare. So I already started speaking in the long 3-hour meeting that I had with the AG earlier, was it last week? Yeah, last week, concerning that. Because we can borrow from the Antiguan legislation to assist the problem here. And I think you're going to need that. I mean, there are other strategies, of course, but we don't know how many classes of a particular type of person are listening to this program. So, you don't let all your eggs out of the basket, so to speak.
But AG, one would ask if it really wasn't common sense that these things were done before. Because ultimately, if you're going to build out a forensics unit, then you should have the legislation in place so the findings that comes out of this forensics unit can be used to the advantage of the prosecutor to ensure conviction for persons who are guilty, of course. Yeah.
I learn from historical mistakes and I try to fix them. So one of my main goals in this office while I sit in this office is to modernize our criminal justice system and our criminal laws. And I'll try my best to do that. I saw the limitations because I'm a former prosecutor. When I came out of law school, I volunteered as my give back to the state to work part-time in the DPP's office. So I understand how difficult it is to prosecute, especially when you have antiquated laws. I remember doing a matter that involved some gentlemen who were stealing, I think, copper from the dump, right? And we had a little technical issues with that matter because of the fact that our last law was a bit antiquated. And the other times that we've had issues with technological evidence, that you felt that, you know, if a jury was able to see this evidence, it would be helpful in the prosecution. So I saw those issues. Now I have the opportunity to try and fix it. I'm going to try to fix it. And I'm very happy. And that's one of the reasons that we chose DP as well, because he spent the last couple of years looking at reforms and doing reports. It's when you have the experience of prosecuting, and then you have the experience of looking at the laws and saying what needs to be fixed, it's almost like a perfect timing for me and him to be collaborating to try and bring those reforms. And what I want, especially having attended the CCJ Academy for Law, the conference, I think it was in September, where this was the topic, criminal justice reform in the Caribbean. And there was a statement issued after the meeting on what we have, from the CARICOM level, have decided is our aspiration with respect to criminal justice reform. I want St. Kitts and Nevis to be the model jurisdiction for modernization of laws and speeding up of the criminal justice process. And as the speaker at the, I think it was the independence lecture said, our size can be our strength. Because we're a small society, we can implement these laws and bring a suite of legislation that can propel us forward. And I want to make a clarification on what I said earlier. The intention is to amend the laws by July next year, so that when the assizes starts in September next year, the new laws and the new processes will be in place. It's not going to change everything overnight because there will be a backlog. But sometimes you have to plant the seeds, to grow the trees, knowing that you won't be the one to benefit from the shade. The Prime Minister said that yesterday and it resonated with me. I don't care if I am the person that benefits from the shade. I want the people of the country to benefit from the shade. And we're now, by July, planting the seeds. And then we have now time for a DPP who's forward thinking to then push the process forward from the DPPO perspective to then set that institutional momentum into force. So hopefully we can see the results of the planting of those seeds in a couple of years.
So just to clarify, the current cases that are existing now, they will not be subject to any reformed laws come July.
Yes.
If you were to have the time.
Yes, they will.
They will.
Because well, they are going through their process now. The minute the process changes, there'll be a couple caught up in the mix, hybrid. But what we're going to do is, for example, if we bring in the plea legislation, the DPP can look at 40 matters and say, oh, these 40 matters here are ripe for me to have a plea negotiation with counsel and the accused, right? And potentially those matters could come off the docket because there might be some people waiting and saying, boy, I think I can get 15 years in jail, you know. If the DPP comes and offers me 5 and the victim is okay with that, then let us do it. So
well, if it's manslaughter, the victim is already dead. Sorry.
In cases that apply.
Yeah, no, I understand. But
I see you're trying to break my seriousness. Okay, go ahead.
Yeah, the Attorney General is quite right. And just to add to what he's saying, like for example, maybe one example from just today. I had one of the things that we want to bring in is special measures legislation, which is desperately needed here in St. Kitts and Nevis, particularly for witnesses who are the victims of sexual assault, or well, let me not say victims, the new terminology, survivors of sexual assault. I had a witness who was a survivor of rape, and she hadn't been inside the court and so on. So I was trying to explain to her what the court is like. And she was so soft-spoken, and I could tell immediately, even though this happened 4 years ago, she is still traumatized by the incident. So I told her, I'm going to work on getting a screen. Because of how the little court is set up, there is nothing blocking the view of the accused from the witness. So it's just a matter of turning so. And you see, and that could just throw you off.
Yeah.
The whole idea of the special measures is to get the best possible evidence in the best possible manner from the witness. That is the only way you will get something credible for the jury. If the witness is frightened, then you're going to have problems. You might have plenty tears and so on and so forth, but make them comfortable. So a screen is an important first step. You don't necessarily need legislation for a screen, but it's an example of things that can happen. I think also she came with a support person. And I said, you know, one of the special measures that we can put in there with the special measures legislation is so that a person can have a support person with them. Not to help them give the evidence, but sometimes, you know, sometimes when you're going through a situation, you need a teddy bear or something, or a person, a good friend, an uncle, whoever. He's just there. And some persons just need that level of support with them when they're giving evidence. So that is one of the things. I mean, it's a ton of stuff now. I have enough problems, right? But what I like the fact that St. Kitts is so challenging, because every day I go home and I'm thinking, okay, let me see how I can try and resolve this problem. I think at the end that the problem is resolved. I have to believe first that the problem can be resolved. And I'm just thinking, okay, I'm going to just work, despite all the stress, to achieve that particular objective. And I think once everybody plays their part, all the stakeholders play their part, once the public plays their part, because the public is a very important aspect of this, you know. And one of the reasons why I like to be on the program is trying to be that face of my office. It won't always be me. Hopefully it won't always be me, right? But the whole idea is I want the public to understand that we care about your concerns. We care about your interests. We may not be able to reach them 100%, but we'll try and see how we can meet you, how we can. Just to give one quick example. Sometimes I've gotten complaints as an issue. Witnesses, they come, they stay a whole day outside the court, only to be told, come tomorrow, right? That's going to stop. That's going to stop. Because we're going to have what we call a batting order. Just who we need for today, we'll call for today. Because there are people out there who are single mothers, who are self-employed, who may only get paid once they work. And another thing we have to look at AG too is, you know, employers who are taking measures against
disciplinary measures, yes,
against witnesses, or not paying them because they're inconveniencing the operations. Giving evidence before a court is one of the most important civic opportunities that an individual in any society can engage in. If you're punishing them or you're causing them to be subject to some sort of detriment for doing that, no, that has to be dealt with under the law. So that's something that we're going to be dealing with very actively as well. So the batting order to avoid the inconvenience like I was speaking to you about, and that. But just an example of some.
Gentlemen, we're going to take this time to take a quick break, a very short break, and we'll be right back with some of this fascinating discussion. And the next question, as you, I would want to turn to you, Mr. Smith,
yes,
and AG, of course, is in terms of engaging the public, because you have a lot of ideas, and the public needs to be able to be informed. The public needs to have that buy-in and understand what the government is doing. But so we're going to take a break. Take the break, and we'll have that discussion.
All right.
We'll be right back with more in Focus.
If you haven't done it as yet, please do it today. Subscribe to our YouTube page at SKNIS Media for regular updates, live coverage, and even more information on your government. While you're at it, like, share, and interact with our Facebook and Instagram pages at SKNIS Media and SKNIS Info.
Welcome back to InFocus. We continue our discussions with Attorney General, the Honorable Garth Wilkin, and the Director of Public Prosecution, Mr. Adlai Smith. So we've been talking about the reforms that are scheduled to take place over this year and next year in terms of criminal justice reforms. And as we mentioned, the public buy-in has to be secured. Of course, as we speak about plea negotiations, we said that the victims, persons who would have been impacted by the crimes, they would have to be consulted. So what strategies are there, AG, Mr. Smith, AG, let's start with you from a ministry standpoint, to engage the public, to identify to them and to educate them on what is being planned?
One of the things I told the DPP when he started was that I expect him to be out there. I expect him to be on radio, on programs, because people must understand how the office works. People thought, I guess because they watch a lot of American television where the Attorney General is responsible for prosecutions. Said, AG, lock them up. AG, prosecute this person. AG. And I've said to people, I have no authority under the Constitution to start, stop, or initiate any or interfere with any prosecution. The constitutional authority lies with the Director of Public Prosecutions. So I think we have to start from that base level, explain to people what is the role of the DPP's office. And also, public prosecutor. The DPP is acting on behalf of the public. It is the state versus the individual. We have decided that these things are against the law, these things are crimes. So the state has an entity in order to protect the people against the persons who commit these crimes. And that is what the DPP's office from a fundamental perspective does. So I've told him, I said, listen, I want you to go out there. If it means that we have to secure a spot for a regular radio program, maybe every 2 months or so, because the DPP is extremely busy. So it's difficult to do a monthly program. But it's important to know. So I told the DPP, go out there, introduce yourself to the people, and let them know what you do. Also, what we're going to try to do as well is something that has been lacking in our society. It's crime reporting. So typically you will have newspapers and radio stations will have people in the court to report what happens in trials. When you have big trials in the US, you see pictures every day from the accused, and you hear this witness, bombshell, cross-examination today. And, there's a public interest because then it should be a public interest in what happens in the courts.
And in some cases, they can witness it themselves. Think of the trial with former President Donald Trump.
Other than sexual offenses, any individual from the public can go and sit down in the High Court and observe a criminal trial. I can tell you, of all the trials that I did, most of my trials I did were sexual offenses, so they were not persons. But maybe around 40% of the trials I did, nobody was there. It was the police officers, the prosecutors, the defense counsel, the accused, and the jury and the judge, and the clerks. So I want society to get more. Yes, people have busy lives, but sometimes they have important trials that are going on that happen after 4. Mm-hmm. You could leave work, go up by the cenotaph, and say, boy, before I go home, I want to observe the rest of this trial. I'll tell you, my father and some older people said to me, people in St. Kitts and Nevis in the 60s and 70s used to go to the court. They used to go upstairs and observe civil trials, criminal trials. They were interested in what was going on. And because we were a small society, but hardly anymore. So the way we bridge that gap now, maybe when the PR from the courts is a little better. So the reporting as to what is happening. The people know, listen, there's a GBH, a grievous bodily harm trial this week, right? Go and see what happens in the trial. We're going to try to get that PR done. And that is more of what our role is from the ministry. Our role is to support the administration of justice. So we don't delve in and get in the nitty-gritty of the trials. That is for the DPP's office. But all of the different things that can make the process more transparent and open, we will support to do that.
And it's certainly an important role for the media to play as well.
Yes,
Unfortunately,
very much so.
Most of the newsrooms here, they are understaffed.
Yes.
And to devote someone to cover a court trial for weeks, maybe months, would be extremely difficult. But it's something that I think the media will have to be engaged with and see where their services can be linked to that.
Yes.
So, Mr. Smith, let's talk to us about the communication strategy from your office. And very quickly, we have about 15 minutes left on the program.
Well, I tell you, 1 hour is not enough. What I would like to see in the future, and this is just one of several ways. You see, people communicate different ideas in different ways. So as we try and reach out to everybody, we try to utilize as many means according to how many people we can get the feedback from. And we want quality feedback in this. I think if we may have one of these sessions where we just take calls from the public, tell me about your problems with the system. But don't just tell me about the problems. Tell me about how you think the problem can be solved, because you have some very unique problems here and so on. And I mean, I'm saying to myself, no disrespect to the country, but I thought that in Antigua is a prosecutor's paradise compared to here. But that notwithstanding, that doesn't mean we can't work to fix what is here. And that's why we're here. We're not complaining. It's better to light a candle than curse the darkness.
So what you're saying, Antiguans love to give evidence?
Well, more than here. Well, there's a greater willingness to give evidence by witnesses in Antigua than here. And I want to understand what is the reason for that. Well, what is the fear? I understand some of it already, but I want to hear live from the people. I want to hear what the people have to say so that we can fashion our solution according to what the people are saying. It's all well and good that I can come up with my solutions, but I find in practice, when you do that without consultation, sometimes you miss that one important fact which will eventually cause the strategy to fail. And this is why consultation with the public is very important. I believe in public engagement. The time must stop when directors of public prosecution, and granted, yes, I'm very busy, and I'm telling you I have plenty of time. I work 7 days a week, I work morning and night, and so on, but I like it. I like it, right? So,
I thought I was the only one who did that.
No, not necessarily. But the point I'm making is that the stakeholder involvement is very, very important, and I will put primacy on that. I would encourage people, come with positive. I mean, whatever's happened in the past has happened in the past. You can't change that. I want us to be forward thinking as a country. And I say us, right? Because right now, as I'm here, I consider myself an honorary Kittitian and Nevisian. AG knows I've asked for a passport to reflect that. So I can tell the jurors, hey, I'm one of you too. I'm interested in what happens to you, because I have an interest, legitimate interest in this. And so I'm thinking, if I bring that human face to the system, and I can show that I'm genuinely interested in the affairs of the citizens of the Federation, we'll get some improvement. We won't get it right away, but if we get some improvement, we'll have accomplished something. And that's all I'm saying.
AG, in terms of stakeholders that Mr. Smith just mentioned, well, what about the regional and international stakeholders? Is there a role for them to play? Take, for instance, the PACE Impact Project,
yes.
Justice Project.
Yes, of course. There is a lot of money out there that is put behind justice reform. So there are a lot of international groups that are set up to help us. When I went to Jamaica, I actually went for the launch of PACE. So that is going to be a support structure. Right now, there's a training that is, the INL is doing a training on asset recovery, free of cost. We've gotten, RSS is willing to support us to train police prosecutors. The CCJ has said they're willing to train personnel. So we have to tap into all of that, and I'm trying to. The PACE initiative is a major initiative, so we look forward to that kicking in, and that will provide some support. We might even get prosecutors to come in, paid for by international organizations.
Just quickly explain what the PACE project is.
It's a project that is it's sponsored by the EU. It's administered by the UNDP, and it's to provide advice and support for criminal justice reform in some jurisdictions. Not all of the CARICOM jurisdictions are a part of it, but we are. And so they're going to basically liaise with us, find out what support we need. So it's going to be a consultative process. So what the launch happened just before the CCJ Academy conference. So that was really just to say, listen, this thing is started. The EU is funding it. We're going to consult with you, and it's going to be bespoke, meaning that it will be consultations specific to your jurisdiction, and consultants will come in, and they will help us with the reform. So one of the points I wanted to mention is that consultation. We're not just going to Parliament and pass the laws. We're going to consult with the Bar Association. We're going to, hopefully, when we have the full suite, we're going to consult with the public, have a town hall, and say, listen, this is what we're planning to do. Because you just don't move to judge alone unless you have some sort of societal buy-in. Immediately, in the immediate future, we have a meeting set up with the Justice Committee. The Justice Committee is the High Court judges that do criminal court assizes, the magistrates who sit in the criminal court, the DPP and the officers from DPP's office, senior police officers in the CID, the Criminal Investigation Department, etc., the Bar Association, and members from the ministry. We had that meeting about a year ago, where we sat down in a room and said, listen, what are the issues with the system? So we got an idea from the different areas, different parts of the system, what are their issues. And we were that's what started the strategy, and say we really need substantive reform. So we're having a follow-up, our next meeting. And at that meeting, what I'm going to do is make a presentation and say, listen, these are the areas of criminal justice reform. Are we collectively as a group ready to implement these things, just from a general, not the fine detail yet, but just from the macro level? Are you prepared for us to have the debate on judge-only trials? Are you prepared for us to remove paper committals and let matters go straight to the High Court? Are you prepared to have juries be reduced? And all those things with all the local stakeholders. So then when we have a package we can put together, we can take it to the Bar Association and say, Defense Counsel, what are your views on this? And then we can have a town hall. People, and have it virtual so people in the diaspora can participate as well. What do you think of this? Let's just get your views. So we can take those into consideration. We can present a full suite. The amount of changes we won't be able to do in one sitting, but hopefully maybe over 3 sittings we can focus on some of the criminal justice reform amendments that need to be made, and we come with a full suite of changes, and we let it roll and see what happens, and we adjust accordingly.
Room for more alternative justice measures such as mediation? Yes.
So one of the things that the DPP said which was needed was a public defender's office. So as I said at the most recent Prime Minister's press conference, we have now have budgetary approval for 2024 to establish the Access to Justice Authority. In that Access to Justice Authority will be 3 arms that affect criminal justice. Public Defender's Office, that is where accused can get free representation from lawyers that are paid for by the state. So that's an office you can go to and get representation. It makes the process easier when the accused has representation, right? And it's the fairest way for things to happen. Then there's going to be the mediation arm, the division, where persons who have disputes can go and mediate before that dispute might arise to a criminal activity. And in that arm, which will work together, it is going to be the restorative justice. Person accused of breaking into a house of your neighbor, gets convicted, spends 2 years in jail, comes back and is your neighbor still. The victim can then now sit with a mediator with the person who has been convicted before they come back into society and work out the issues so that there can be a resolution, truth and reconciliation before that person comes out, so that when they come out, there's hopefully no more conflict. So those elements of the Access to Justice Authority will help with to promote peace and tranquility, and help with the criminal justice system. Because then now, if that person comes back out, that person has a truth and reconciliation with the victim, they might not become a repeat offender again, and they stay out of the criminal justice system. Because one of the things we haven't discussed is, we're discussing the criminal justice system, we're not talking about keeping people out. We don't want there to be crime.
That's a whole new conversation.
That's a whole different conversation.
And it's something I'm sensitive about too, the rights of accused persons. Again, I can't say how thankful I am for my previous position, because it's just opened up my eyes and broadened my horizons with respect to how you deal with people. I throw this out there. You put persons in prison without adequate rehabilitation programs and so on. You treat them as inhumane. You interfere with their dignity by the conditions in which you keep them. You treat them like dogs, basically. I'm not saying it happens here. How would you expect that type of individual to come out like a rabbit or behave like a rabbit, gentle? My thing is, you treat people like animals, they will leave like animals. You treat them like persons, you reduce the risk that they will come out like animals, because sometimes you can't get rid totally of that animal instinct. But I'm thinking, if we have like a communication, if we have, okay, I'm trying to see if I can meet your needs so I can make you a better person, if we can put you on some sort of employment program, if that is your problem, or education, right? Something like Seeds of Hope initiative, which I had a part to play in. And that's getting short courses at the University of the West Indies for persons who are incarcerated. But we need to go the next step. We need to have opportunities whereby persons can use the skills that they have learned and become creative individuals. And Jamaica has been an excellent example of that. I was here last year for a prison reform symposium sponsored by Impact Justice. And I guess when the time comes, we can have that further discussion. But it's something that's also on my mind too, because as a Minister of Justice, the Director of Public Prosecutions has tripartite interests. He considers the public, the interest of the victim, but also the interest of the Constitution and the accused. So it's not narrow-minded. I'm a Minister of Justice with a wide ambit of responsibility.
Mr. DVP, talk to us about the client care unit that you referred to.
Oh, yes, yes.
Very briefly, yes.
Yes. Now, allied with the client care unit is something called witness, or is witness? Yeah, witness bill of rights. What's a witness bill of rights? We always talk about the criminal justice system skewed in favor of the accused, right? But what about the rights of witnesses? Victims. Don't they have a right to know, for example, where their case is in the system, what's happening with their case? Don't they have a right to be consulted about important decisions concerning their case? The right to be pointed in the direction of opportunities, for example, with respect to counseling or different services of government which are available to them, things like that. And the whole idea, one of the functions would be to assist in enforcing informally a bill of rights, so to speak. So when somebody wants to find out these things, of course you have to educate the public about that, what's available. Otherwise, nobody's going to call concerning that. And I think that is important to show that there is some sensitivity on the part of our department towards the interests of witnesses. Client care will also take care of complaints from members of the public in relation to members of my office, or maybe even members of other organizations. And I guess the interaction between the police and the public can be another discussion, because I've heard certain things there, but it requires a discussion. And client care also too would be responsible for monitoring media reports. One major function of the Director of Public Prosecutions Office is the management of risk, right? And anything which is in the media which is likely to pose what I term reputational risk, I think it's important that we know about that. So persons who would be part of that committee will be monitoring media to be looking for that. But of course, that's all in the idea stage, because I have to figure out how I can make it work for this with the small staff that I have presently. But I know AG is going to assist me in increasing the staff complement to enable to fulfill those particular objectives. But that's just an example of some of the things. There are other things, but that's an example of some of the things the client care unit would be dealing with.
AG, we have less than a minute left, so I'll give you an opportunity to make any final comments.
Yes, the goal is to have swift justice, to have our criminal justice system working efficiently, and for our prosecutors not to be overworked, to have the support that they need to be able to do their very important job, and to modernize the process and to modernize our laws. So it's multifaceted what we're trying to accomplish. And I think with the ministry ministry and the AG's office collaborating with the DPP's office, I think we could accomplish those goals. As I said, the ultimate goal is for our justice system to work such that you're not waiting more than 2 years for your matter to be resolved. And what that does as well, it protects the public purse. Because when there is delay, there are constitutional issues. When there are constitutional issues, people sue. When people sue and have constitutional breaches, it's hundreds of thousands of dollars that come out of the public purse that are paid to people. So if you reduce the time that the person waits within the reasonable realm, then you can put that money towards reform and towards the DPP's office being more efficient, and it just kind of snowballs into a more efficient system where the money is spent up front, and some of that money can actually go to rehabilitation.
Right. AG, thank you very much for appearing on the program. We certainly would like to have you back. And Mr. Smith as well, as we roll out a bit more and learn more about the processes that will be implemented, particularly as it comes to the public consultations. You know, the persons would have to be made aware of where and when.
Yes.
And so we certainly look forward to sharing that information, as of course InFocus is the only government program where persons can get information from officials from the government. Of course, you would do some media appearances, independent media, but InFocus is the primary force for the government.
And next time you have the DPP, please ask him to sing. He's quite a good singer.
Yes, I did see that, and of course DPP, we certainly would love to have you back as well too. And we know that most persons, your faith is something that guides you. Unfortunately, we didn't have time to discuss that because most persons might have been familiar with you or introduced to you during a presentation that you made at the Antioch Baptist Church, where you spoke about your first case and how it went and how your faith came in. And so for those who are interested, they can go on the Facebook page or the YouTube for the church and find that insert there. So we'd like to thank you, Mr. Smith, and also AG for being with us today on InFocus.
Can I even hail with a little comment? I just want to hail the hardworking members of my team. I just want to big up Miss Gordon Hazel, Mr. Vasquez, Miss Campbell, Miss Lieberd, Miss Nisbet from Nevis. I can't forget Nevis. That's another program altogether.
Mr. Lawrence.
Oh, Mr. Is it like so many? Right, but my hardworking team makes it easier for my work to flourish or to bear fruit. And I don't consider myself in a vacuum. I am what I am. I'm this motivated and excited about the job because I have hard-working team members behind me. And I just want to hail them in the process because they're the wind beneath my wings.
When you give names, you get into problems sometimes.
Sorry?
When you give names, you get into problems.
Oh, yes. Imagine I am struggling to remember because so many.
Right. So thank you very much, Mr. Smith. AG, we certainly love to have you back.
Thank you.
We'd like to thank you, viewers and listeners, for joining us for this edition of InFocus. We trust that you would join us next week at the same place, at the same time for another edition. I'm Ian Richards.
Join us every Wednesday for InFocus, a weekly talk show produced by the St. Kitts Nevis Information Service, where we provide exclusives with key persons within the government and discuss pertinent, relevant, and interesting matters that affect us all. Tune in every Wednesday, live on ZIZ Radio and streamed live on Facebook at SKNIS Media and ZIZ Online. InFocus, your government, your business.